Welcome to Lawyers Info. It's a pleasure to create content on this platform. So today we're looking at corroboration in law and when it is necessary. You ask yourself, what is corroboration? What is corroborative evidence? As a law student, you'll be taught about corroboration in your law of evidence. And as a lawyer, you'll meet corroboration in your daily practice in courtroom as you're preparing to take up your cases during trial. This word corroboration will come up, and in analyzing or evaluating your evidence, this is very key in understanding what it means and what is needed and how to prove it, how to when it's necessary and when it's not necessary. So when you talk about corroborative evidence, what are you talking about? Is that evidence that is offered to supplement an evidence that is already given, aimed at what strengthening that evidence or confirming it. We already have an evidence. You're looking for another evidence to confirm, to strengthen what you already have. That is when the word corroboration comes into play. And a corroborative evidence is that evidence that is what you know tender to strengthen what is already on ground, to confirm it, to validate it. Yes. Now the question is, how can corroboration be done? Corroboration can be oral, it can be direct, it can be documentary. We have circumstantial corroboration or even corroboration uh, by conduct. It's also very important to note that when a piece of evidence that requires corroboration cannot be used to corroborate another that requires corroboration. Yes, if a piece of evidence requires corroboration, you cannot use another evidence that requires corroboration to corroborate it. It's as simple as that. So when you need an evidence to corroborate the one you have, you must be sure that it's not one that needs corroboration. Now, a lot of people have argued, when people silence, does it amount to corroboration? Now, there have been lots of arguments on issue of silence amounting to corroboration, looking at the issue of Section 3611, sub 11 of the Constitution, 1999 Constitution of Nigeria, which gives right to an accused person to remain silent, and the fact that an accused person cannot be compelled to give evidence. So people have just opposed it to the fact that when someone keeps silent, can it amount to corroboration? Let us not forget that corroboration, there's evidence of admission by conduct. Also, there is a way someone will behave to give credence to what he or she has been accused of. This is issue of admission by conduct. When you're supposed to refute something, you did not refute it. When you're supposed to protect something, you did not protest. There's an admission by conduct. Now, remember, in corroboration in criminal cases, the rule is that corroboration applies only to the prosecution witnesses and not that of the defense. And the fact that the corroboration must implicate the accused of committing that offense. There's two joint requirements needed. The corroboration must show the fact that the offense was committed and that it was the accused that committed the offense. Now let's look at cases when corroboration is necessary, either by law or by practice. The evidence of an accomplice. The evidence of an accomplice that it is. Who is an accomplice? Accomplice is a person who participated in the commission of a crime. Now you can see you still have the concept of a principal, accessory, before or after fact. The evidence of an accomplice requires what? Corroboration. Now also look at um, the evidence of a co-defendant. The evidence of a co-defendant also needs what? Corroboration. The court always, restrict itself to the strict warning or the fact that it's unsafe to convict someone on an accused on an evidence that is not corroborated. Now, under treason or treasonable felony, it's important to know that the corroboration is required. That requirement of two witnesses, testifying to the over act of treason is it's really important. Even though there's an exception, where the issue of treason is towards the killing of or endangering the life of a president of the federation, then the requirement of those two witnesses is not valid. Under the offense of perjury, corroboration is needed, to validate the evidence that is in the linking the accused to the offense of perjury. Under exceeding speed limit, is important also that evidence is corroborated, before someone can be liable of committing of exceeding the speed limit under the road traffic law of a state or road traffic act. Now, under the offense of sedition, it is important, it is necessary that evidence is what? Corroborated. Very important. Very, 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 very important. Now, under the evidence of a child, you know that the child is a competent witness, unless in the opinion of the court that the child cannot understand rational questions or cannot even understand the questions being put to it or cannot give rational answers. And we know if a child is above the age of 14 and when the child is below 14, the impact of the evidence of that child. Now, generally, the evidence of a child needs to be what? Corroborated. Needs to be corroborated. Though it is good practice that the sworn evidence of a child should be, this good practice should be what? Corroborated. Now, under the breach of promise of marriage, an action for breach of promise of marriage shall not succeed on the uncorroborated evidence of the plaintiff. So the evidence for to clinch on this on the issue of breach of promise of marriage, you want it to thrive, then the evidence has to be corroborated. It's very, 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 very important. Now we also look at issue of agent provocateur. Who is an agent provocateur? Is a person who joined in the commission of a crime solely for the purposes of collecting that evidence against the defendant. Now, so the evidence of an agent provocateur is required to be corroborated. Now, a tainted witness is a person who, though not an accomplice, has some interest or purpose of his own to serve. So, such evidence of a tainted witness needs to be corroborated. Now, it's very important to know that what is the effect of the absence of corroboration? Absence of corroboration, what is the effect? Now, there are two situations that must be considered. If corroboration is required under the Act, then corroboration is mandatory based on uncorroborated evidence should be quashed. Yes, if the Act says for this instance or for offenses like this, corroboration is important or required or mandatory, then the evidence to be used in letting the accused to the offense must be what? Corroborated. Now, it's also very important to note that if corroboration is required as a matter of practice, then a corroboration may or may not be quashed depending on whether the absence occasioned the miscarriage of justice against the accused. This is very key. This is always argued on in the appellate level, where they say, okay, where there was an absence of corroboration when in practice they're supposed to the evidence ought to be corroborated. Did it cause a miscarriage of justice? Was there a miscarriage of justice because of the absence of corroboration? So in the appellate court, these are what the court will look at and say, well, I do not think that the absence of corroboration in this matter, led to a miscarriage of justice. Or will say, I think that the absence of the corroboration in evidence of this witness that was used to nail the accused to the crime, is occasioned a miscarriage of justice. So these two issues are always considered by the court when evaluating the absence of corroboration in a matter where corroboration is what required. So we have looked at corroboration. Look at what is the corroborating evidence, which is that evidence that is used to supplement and already given evidence to what strengthen it or to validate it, to confirm it. Very important. We've looked at whether silence amounts to what corroboration. Just opposing it with section 36 sub 11 of the 1999 Constitution. We've looked at corroboration in criminal cases. We've looked at instances where the twin requirement of corroboration, which shows that the corroborating evidence must show that there was a commission of the crime and that the accused person committed the crime. We've looked at instances where corroboration is necessary. We've looked at the evidence of an accomplice, a co-accused, offense of perjury, sedition, treason, treasonable felony. We've looked at exceeding speed limit. Also looked at agent provocateur. We have looked at breach of promise of marriage. We've looked at evidence of a child. So in these instances, it is unsafe to convict an accused on uncorroborated evidence of a witness. So corroboration is very key. It's very key in analyzing evidence in a matter, both criminal and civil. Corroboration is key. So the courts are being warned in practice to take it easy. When you want to convict on an evidence that is uncorroborated. So in practice, the courts warn itself, not to convict you know, where the evidence is uncorroborated. So corroboration is very key. It validates, it strengthens, it confirms the evidence that's already on ground. So, friends, I just hope you'll be able to learn something from today's class. If you're yet to join the family, the Lawyers Info Hub family, please do hit the subscribe button, join us, and you will not regret it. We have so many legal contents on the platform. Please do check it out. And you will be amazed at the level or the depth of the content we've been sharing on this platform. Thank you, my returning subscribers, for always stopping by to check what is new on the channel. And for you to see me for the first time, you are welcome. And I know you will enjoy your stay on this platform. Do take care of yourself. And you know what? You can always be the best wherever you are. Just keep pushing, be the best, be resilient. And the sky can be your stepping stone. Do take care.